that did not include any major contested statewide primary on either side or race. So even absent a highly contested election, these policies in and of themselves increase significantly voter turnout on both sides of the aisle in the state of Michigan within a year of them becoming a mandate in our state constitution.
Thank you very much. Thank you to our witnesses. I'll turn over to Senator Blunt.
Thank you, Senator Klobuchar. Mr. Walden, I think I'll start with you. You mentioned, as Senator Klobuchar did, as others have, that the last set of elections were the most secure elections ever. You accepted that and have repeated that. It seems to me, based on that, there'd be no reason to have this discussion unless you could create a false narrative, in my view, that somehow states are passing massive legislation that changes the voting structure to people's disadvantage. Now, that's different than individual members of the legislature introducing bills. You said the last set of legislative bills are more bills than usual. Now, actually, I think on the Republican side, 22 bills of those bills are in Arizona, and 22 or so of those bills are in Georgia, which I suspect my back of the envelope calculation would indicate that the 4, 5, or 6 bills in other states is about right. Believe me, politicians believe they are election experts, and there are always bills passed, always bills filed, almost none of which pass. Every article on this topic cites your organization and all of this voter suppressing legislation that, one, all isn't voter suppressing, and two, just simply is not going to become law. It's a great excuse to upend a system that served the country well for a long time. On the Utah bill, for instance, that I cited earlier, HB 12 requires the lieutenant governor, who's the chief election authority, to provide Social Security data of deceased individuals to county clerks so they can begin the process of removing deceased individuals from the voter rolls. Why would that be voter suppression?
Well, thank you, Senator. When we look at legislation across the country, we look to see whether the measure is potentially restricting or suppressing.
Just on the question I asked, why would that bill removing dead people from the voter rolls based on Social Security information be voter suppression?
Because there are frequently errors in the lists that are used in Social Security and other.
So your view would be the federal government is not capable of telling the state which Social Security recipients died and no longer get a check, so we should turn the entire election over to a federal structure. I just don't agree.
Senator Blunt, can we allow the witness to answer the question, please?
No. The witness did answer the question. Okay. The witness answered the question, Secretary.
We'll clarify it later.
Senator, the witness answered the question by saying the federal government often is in error in giving information to the states. That was the answer to the question. Let's go to the Secretary of State Warner, who's here, and the other two as well. You know, we had 3 different views of this from 2 current secretaries of state and one person, Attorney General the Attorney General of Indiana, who was the Secretary of State until the end of last year. I think to some extent that may show why one size fits all maybe doesn't ever fit anybody very well. Secretary Warner, what would be the challenge? You said you'd have to have a special session in the legislature, you think, if this bill passed, and tell me again why that would be the case.
The expanse of this bill would force states to address these issues, such as the funding to get these new machines. When this decertifies all the machines we have in West Virginia, we have to go back and get new machines. That's quite the process to find that funding, to then put it out for bids, that sort of thing. I want legislative directive. Again, that's what our Constitution says. It's going to be left up to the states, and so I want that direction from the legislature to tell me, so then I can execute that, the provisions to implement this vast, as I called it, monstrosity of a bill. There's just too much in there. The clerks are extremely against the same-day voting, same-day registration aspect of this bill. That just would overwhelm them And as I said, when you don't have the broadband capability throughout the state, it's an impossibility. And so then our legislature would be up to trying to find a way to address what Congress is passing down to them, but then meeting the reality. That's the problem of so much of the discussion that's going on here today. It's talking points versus reality. And that's why I always turn to my clerks, and my clerks tell me that, and unanimously across the board, they are against this S1 because of the unfunded mandates and the expanse that it would impose upon them in the election administration.
And Attorney General Rakita, you said you thought there'd be immediate legal action by a number of states. What would be the principal legal focus of that action as to why this should not move forward?
Thank you, Senator. Well, of course, the constitutionality of this all is immediately called into question, not just with regard to the framers' clear intent that state legislators and legislatures determine these rules, but also in terms of redistricting, which would be completely usurped by the federal government and particularly unelected judges. The people have the most power in this situation when they can hold directly their representatives accountable for redistricting processes. So that's a huge problem. The private right of action that's in this bill that was not in the Help America Vote Act is also a huge problem. When you have individual citizens, like, for example, a prisoner who decides that his rights were now violated as made up in this bill, can sue the states. Untold amount of litigation will happen. So it's not just the states against the federal government. It's this bill would give rights and private rights of actions to citizens for their apparent, not real, grievances, and that will drive up costs to states significantly.
Thank you, Attorney General Rakita. Thank you, Chairman.
Thank you very much. Mr. Waldman, 30 seconds. Do you want to finish answering that question before I turn it over to Senator Feinstein?
You know, I would say, Chairman, the 5 minutes is mine. It is not.
I am not going in your time. You went 6 minutes.
It is not Mr. Waldman's. I didn't take the 4 minutes you took before the clock started,
now.
or the 1.48 minutes after.
I simply want to give Mr. Waldman 30 seconds to finish answering the question, and that is my prerogative as chair.
Well, if I'd have given him 30 seconds to answer the question or another minute, I wouldn't have been able to answer my questions within near the 5 minutes that every member should be restricted to here.
Madam Chair, I think the senator from Missouri took 6 minutes and
Yes, I was
12 seconds
generous in the
of his
time.
5
I
minutes.
was generous in the time.
This-
Mr. Waldman, could you just
Madam
finish answering the question? Oh, my goodness, what?
Well, I will
Could
be
you
brief.
let the witness, please, Mr. Wicker, could you, Senator Wicker, let him just finish? 30 seconds.
I will be brief. One must be very careful when purging voters from the rolls to ensure that the lists are checked and double checked. Unfortunately, there are errors, and that's why voters should have protected rights, as in this bill, to ensure that they are not being removed from the rolls when they ought to be eligible and ought to be able to vote.
Thank you. Ms. Senator Wicker.
That a witness can filibuster an answer and take up 5 minutes of a senator's time. So Senator Blunt was well within his rights to cut that off, to move on to other matters. But if the chair in this committee on this important day, where we have 2 panels, is going to run this committee in a way that I've never seen in 13 years, then I will point out that this is quite irregular.
Excellent.
Thank you, ma'am.
So I will note that testimony is supposed to be 5 minutes. and the time can be extended by the chair, including for questioning, which I just did for Senator Blunt, and I'm sure we can work that out. And I will say what's unprecedented is that we're finally having a hearing about something big. We're finally having a hearing in the Rules Committee about an actual bill, and that everyone's here in this beautiful room. That is unprecedented. And I will be nothing but more than fair as we go forward, because I understand how important this is. And with that, I turn it over to Senator Feinstein. Thank you.